I'm Bridget Marsh, Deputy General Counsel of the LSTA, and welcome to today's podcast on the LSTA's form of assignment agreement. So in this podcast, I'll be talking about how a person drafting the agreement should handle it, and then I'm also going to be highlighting some of the issues you should focus on if you have to complete a form of assignment agreement for a trade. Could be a par trade, could be a distressed trade, but two circumstances will be addressed throughout the podcast. Now, most of you will realize that the assignment agreement is always attached as an exhibit to a credit agreement. However, about 4 years ago, the LSTA updated our form of assignment agreement for some very important reasons, and it recently came to my attention that the form isn't always being used. So we're going to try to encourage everyone out there to at least use, adopt, attach the LSTA's form to their relevant credit agreement. Now, the assignment agreement operates to transfer all the rights and obligations of an assignor under a credit agreement to the assignee. So what does that mean? We've got a seller of a loan and a buyer of a loan. They've entered into an oral trade. They evidence that trade on the LSTA's par confirm, and that par confirm states that the parties are then contractually obliged to settle that either as an assignment or as a participation. There's also a third option, but rarely, if ever, is that used. So, majority of the time, in fact, in our market, about 95% of the time, loan trades are settled on an assignment agreement. Now, there are some key provisions in the assignment agreement, and like many of the LSTA's forms, it's broken out into only 4 or 5 pages. First part, some blanks for all of you to fill in, and at least in my experience in private practice, the checking of these types of exhibits was left to the junior lawyers. So hopefully this podcast will be helpful to those of you at 2 a.m. who have to check your form of assignment agreement. So typically in the first couple of paragraphs, it'll state that the assignor is assigning to the assignee all of its rights and obligations, all of its rights to sue, to make a claim against the borrower, etc. Everything, that bundle of transferred rights is going to be passed over to the assignee, the buyer. Now, this is where I'm going to do a big plug for the LSTA's form. If you have a look at footnote 1 on the LSTA's form, you'll see that it makes it known that in our form, there are no square brackets relating to any substantive issues in the form of assignment agreement. Now, that came to light about 5 years ago at the LSTA, that for those assignment agreements where there were square brackets that needed to be filled in by an assignee, the electronic settlement platform that handled the loan trade, and let me just say, pretty much every par trade is settled on an electronic settlement platform. The person at that platform would see the square brackets, create what's referred to as a pop-up question, and they couldn't then populate the rest of the assignment agreement. The assignee typically would get incredibly frustrated. A pop-up question would appear, and maybe it didn't get in sync with the definitions in the credit agreement. Typically, there was some type of glitch. They had to get a lawyer involved. Well, sadly, it's come to my attention that there are still many assignment agreements that include square brackets that require the settlement platforms to create a pop-up question. So my plea for you watching this podcast is please make sure that you don't have any extra unnecessary square brackets in your assignment agreement. Because it's another thing. It's not a lawyer who's creating the pop-up question. So please don't think that you're going to be sort of helping or protecting your borrower. It's just not worthwhile. So on the second page, you'll notice that there's some information about the loan trade itself that you'll need to include. You'll have to specify the facility assigned. is it, if it's in one credit agreement, going to be the revolver, the term loan B, or term loan A? You'll have to specify that. Also, you'll have to include the aggregate amount. So let's say all the loans outstanding in the term loan B, and then maybe the amount that your particular seller, otherwise known as the assignor, is going to be selling, and then complete the relative percentage of that global amount that's going to be transferred. Oh, and very importantly, include the CUSIP number. That's key. Moving on to the second page, you'll see that there's an effective date that the administrative agent will complete. So once this form has all been completed and the names have been filled in and all the consents have been obtained, so typically on the consent side, the borrower, if it's a new lender, they're not, let's say, an affiliated lender, will indeed have to consent to the assignment. Here too, just go back and check your successors and assigners provision in the relevant credit agreement, and just make sure that you've included the borrower deems consent language, which the LSTA promulgated, I think it's about 9 years ago now. So the borrower is given a period of time, typically a week, to consent to the assignment. If they haven't consented, they're deemed to have consented. And then the agent too may have to consent, or perhaps the agent only has to acknowledge the transfer. Just double check what your credit agreement requires. Then moving on, you'll see the standard terms and conditions are all set out. Both assignor and assignee will be given your basic reps. I have the corporate power to enter into this, the authority to enter into this agreement. The usual corporate reps will be given, just a handful of them. And also the assignee will give the rep that it's made its own credit decision to acquire this loan. So moving on then, there's in the LSTA form a section 2 called payments. It's another important section. I just wanted to highlight this one as well. The vast majority, perhaps even well over 95% of loans, I'm just throwing that percentage out there, are paid out to assignor and assignee in the following way. The administrative agent records the effective date of the relevant assignment agreement, and then all the interest which has accrued up to, but excluding the effective date of the A&A, is then going to be paid to the assignor, right? And everything from the effective date and after, all that interest that's accrued from that date onwards, is going to be paid to the assignee. Makes sense? And I would point out, those of you familiar with the LSTA documents, the confirm, will know that we handle any type of, lack of a better word, reconciliation that needs to take place. Because sometimes these trades do take unfortunately, longer than 7 business days to settle. So interest after T+7 is always paid to the assignee, but the seller under the terms of the confirm pays that amount, not the assignment agreement. Only the assignment agreement is passed to the agent. And then I should say that we do have an option in the footnote relating to the payment section that the agent can in fact pay out all the accrued and unpaid interest up to the, on or after the effective date to the one assignee. So everything, no matter when it has accrued, is going to be paid over to the assignee. Now you think, how do you handle that? Well, about 10 years ago, we heard of some newcomers to the market who were very familiar with paying out bond style. And that's, from what I understand, how bonds typically pay out. So I think most of the systems now have been built in the way I first mentioned, and how Section 2 of the LSTA's LSTA's A&A handles it. But just be aware of that. There is an alternative provided for in the footnote. So the form of A&A, as I said, bit of a lowly document, but once the parties sign off, get all the consents, the agent will then record the effective date, update the register of lender. Now it's at that stage that the assignee becomes a party to the credit agreement, becomes what I like to say is the capital L lender under the credit agreement. So with that, I hope I've explained a few of the key provisions of the form of assignment agreement. Thank you.